We're on the record in cause number 323892, the state of Texas versus Derek W. Howard. We have present in court Mr. Howard, who is sitting by the bar, and we have also present his attorney, Mr. Jack Lawrence. Mr. Lawrence, would you please have your client sit at one of the chairs at council table?
Would you like to come up here? Good.
Okay, and Mr. Lawrence, put your mask over your nose and your mouth, please.
Sir?
Put your mask over your nose and your mouth, please.
Yes, sir. Yes, sir. I can't put it over my nose with this particular mask because it causes vapors all over my glasses.
Well,
But
you don't
this,
have,
I can
you
put
don't
it
have
up here.
glasses on now.
Huh?
You don't have glasses on now.
If I have to use, okay. Yeah, I'll do it.
Okay. Okay. Now, let's see. The court has several motions before it today, and Mr. Lawrence, you've set these cases on the court, set it for pretrial hearings on several motions. Now, I think that you said you had an order that the first motion, the first two motions rather, that the court is going to address and allow you to present your arguments and evidence. The first motion is titled Motion to Quash and alternatively to set aside the information. And the second motion, and that motion was filed on November 19, 2020. And the second motion is motion to quash and alternatively to set aside the motion, or set aside the information number 2. Now, Mr. Lawrence, before we proceed, let me have your client come forward, and he can stand at the bar at the front. Now, no, stand at the front, at the head of the table. Okay. Now, Mr. Howard, would you please raise your right hand? Mr. Howard, do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Howard, you may put your hand down. Now, Mr. Lawrence, let me just ask a basic question. Now, these motions, are they totally different?
No, they're not, Your Honor. One of them is, the first one is about you can't bring criminal charges on guilt by association or the similar thing to guilt by association, which is
okay, Mr. Lawrence, let me rephrase my question. The information that is in the first motion, is it also in the second motion?
there is some from, they have seemingly common information, but what you need to understand is that this is an excerpt directly from the tapes. The ones in italics come directly from the tapes or from the officer's written report. What you have to understand, Your Honor, is that both motions are about an invalid arrest.
Okay, so the reason why I was asking that question is because if the same allegations was if put it like this here, if the allegations are the information that you have in one was in two, we would just take up two. But
no, that's not the
they're
case.
not, then what we'll do, we have to take them up each one of them individually.
Yes.
Okay,
yes.
so
This
which
is-
one would you like to proceed on first? The first?
The first is actually more about, it contains more of a applicable law. I had time to research it more. It basically is about guilt by association.
Okay, so my question is, so we're gonna proceed on your first motion first?
Yes,
Okay, so we're gonna proceed on the motion that is titled, motion to quash and alternatively to set aside the information.
yes, Your Honor.
Okay, now, okay, Mr. Lawrence, are you ready to proceed?
Yes,
And Ms. Musgrove,
Yes,
uh,
Your Honor.
representing the state, are you ready to proceed?
Yes, Your Honor.
Okay, now, Mr. Lawrence, you may proceed.
well, basically, Your Honor, if you would, if you'd look at the bottom of page 1, which that's the most relevant statement of facts. The Officer Reeves had both parties handcuffed. And then one of the officers, and this is on the video, he read both of the parties their Miranda rights at the same time, very rapidly. I mean, in very short order. And then Officer Reeves stated, what I'm asking y'all is, this is after they've been told they can remain silent. He says, whose synthetic marijuana is this? And then he says, if nobody claims it, I can charge you both with possession. And then he says, and he points, as each time he points at one of the parties as he says this, is it your marijuana? And yes, he pointed at one of the parties, and then he pointed at the other party and says, or is it your marijuana? And neither one of them answered, which they had just received their Miranda warning. And he then says, all right, that's the way we're going to do it. Right now, you're both under arrest for possession of marijuana. Now, I listened to the tapes, the videotapes, very carefully to make sure I got every word exactly right. These are exactly the words. And that is not a valid arrest. And then I give the cases of why you cannot arrest somebody for guilt by association. And incidentally, Ms. Fields, on a different part of the videotape after they're in the squad car, admitted at the end of the videotape in the squad car, she admitted that it was her stuff. And so, but I've got a lengthy legal discussion of the cases. I also cite the law of affirmative links, which I go into in more detail in the motion to dismiss, because affirmative links is normally treated as an insufficient evidence ground and would not be used as a basis of a motion to quash. But then I cite that this violates their due process rights under the 14th Amendment and First Amendment, incidentally, because they're being pushed into something. And yes, more discussion of my alternative constitutional grounds in the federal case law on the third page. But they can't use the fact that they were together riding in the car as the basis for making the arrest. That's guilt by association. They actually have to have a culpable act or omission to have a crime, and they do not have that. And I get into that more in other motions, but these are his exact words, and he cannot do this. He cannot say if nobody claims it, I can charge you both with possession and then ask them, is it your marijuana or is it your marijuana? And nobody says anything. They say, okay, you're both under arrest. That's an invalid arrest. He's imputing guilt. He knows that one party might be guilty of something, because particularly when she had it in her purse. He knows that one party might be guilty of something, but now he's going to impute guilt simply because nobody will give him an answer. That is an invalid arrest. And it's not, it won't hold up. It simply won't support these charges. And that's my argument on that, on
Okay.
the quash number one.
Okay, now, Ms. Musgrove?
Yes, Your Honor. I just want to state first that Mr. Lawrence just misspoke about the location of the synthetic marijuana. I believe you just stated that it was in the co-defendant's purse. Is that correct?
It was in the co-defense person on video. You can see that was that was next to the passenger side door.
Okay, so the video that I watched, Mr. Lawrence, it does not show that the synthetic marijuana was actually inside of the co-defendant's purse. So maybe this is a point where a jury would actually be able to view this video, because I'm not in agreement with you on that point, Mr. Lawrence, of where the synthetic marijuana was. But first, I'd like to say that the defendant and his co-defendant, they were arrested for intentionally and knowingly possessing a controlled substance. Here it's shown that they were both in care, custody, and control of the synthetic marijuana. The defendant was in care, custody, and control of the vehicle as the driver. So that is the basis for the arrest.
May I respond?
Okay. Yes, Mr. Lawrence, you may respond.
The vehicle they were in was very largely not under Derek Howard's
Mr. Lawrence, put your,
custody and control either, because the vehicle was his steady girl's car, and her name is Anna.
I'm sorry, his what?
Steady girl. At that time, she was his steady girl. Derek lives with her. And at that time, he was living with his girlfriend in the apartments at 3055 Dallin, 3055 Dallin. Jaylon Fields, the co-defendant, showed up there at his girlfriend's apartment, who was not there at the time, around 5 or 6 p.m. And her car wasn't working very well. And she also had some plans to party somewhere that fell through. And so Derek's girlfriend was at work. And so he wanted to cheer Jaylon up, who they had been close about 6 years before. So Derek borrowed his girlfriend's car and went riding with Jaylon. But it's not under, the car is not under Derek's custody and control most of the time. It's his girlfriend's car. And if they had checked things out more carefully, whenever they tried to identify the car, they would have discovered something. His girlfriend works for the feds. And
I'm sorry, his girlfriend what?
His girlfriend works for the feds.
Okay, so the owner of the vehicle works for the feds.
I didn't hear you.
Are you stating that the owner of the vehicle works for the feds?
Yes. Yeah.
Okay, I'm sorry, I couldn't hear you.
Now, so anyway, Derek was driving the car because it's his girlfriend's car that he lives with, and he was borrowing it because Jaylon's car sort of broke down. It wasn't very seaworthy at the time. And so they were just out riding around and enjoying themselves. He was, basically Derek was trying to cheer her up. Is that about right?
Okay.
I couldn't hear that.
So, and I just want to state that even if Mr. Howard wasn't the owner of the vehicle at the time of his arrest, he was in actual care, custody, and control of that vehicle at the time of the arrest.
I would say this, maybe of the vehicle, but not of its contents. Maybe of the vehicle, maybe he was in control of the vehicle itself in terms of driving it, but he's not in control of whatever Jaylon brought along with her, either within or outside her purse, and that the videotapes show whenever they recovered the material that it was right next to her purse, right next to the passenger's door.
Oh,
Right.
okay.
Adjacent to all that.
Okay. So Mr. Howard and Miss Fields, as both of them were in the vehicle, both of them had equal access, or both of them had the same amount of, I guess you would say, reach to the item. Just as Mr. or Miss.
So I can reach over the console to the driver's side?
Where her purse was not accessible to Derek. You've got a black Camaro with two big bucket seats and a console, and he could not reach back in behind her bucket seat. It was the baggie was outside his reach. It was inaccessible to him because it was over next to, and you'll see this on the videotape when the officer who reaches in over her door, he never opens her door. He reaches in over her door with the glass rolled all the way down, and that's when he digs out this stuff. You'll see that it's right up against the door because his arms are firmly against the door as he's reaching down there to where her purse and the contraband was.
Okay, so I believe that's a question of fact that a jury would be able to make a determination of. Based on my view of the video, both parties or both defendants could have reached the space where the officer pulls the bag from. So I'm guessing that it's just a matter of perception here.
Mr. Lawrence?
Yes, Your Honor?
No, I was gonna tell, while you was talking, Mr. Howard started talking at the same time. Mr. Lawrence, would you please instruct your client not to make any statements during the arguments of either you or the district attorney?
Okay, but please don't interrupt.
Whatever you have to say to your attorney, you can do it in private to your attorney. Okay. You have anything else, Mr. Lawrence, or do you want to go on to the next motion?
I will just insist that the contraband, whether it was within or exactly next to her purse, was inaccessible to Mr. Howard while he was driving the car, because as you will notice, when the police officer goes down in there, it's behind Jaylon's bucket seat and it's right up against the door. His arms are against the door as he's reaching down. First thing he does is pick up her purse and pull it out of the window. And at that time, he turns the snap on it. And that makes me wonder if he's already opened the purse. Well, you can't see what he did pass down where his hands, you can't see down where his hands are during that search. And he could have opened the purse and emptied out the baggie, but you can't
Okay,
see that for sure.
and-
So
yes,
he
and we
turns
can't,
the
we
snap
can't,
on the purse like he's closing the purse. Then he puts it on the roof of the Camaro, and then he says exactly these words, "Hell, I should have smelled it." And then he reaches down and picks up the baggie, just exactly in that order. Puts the purse on the roof, reaches down and picks up the baggie in exactly the same location the purse was at, behind her seat and next to the passenger door. And that in a car with big bucket seats and a console, that would have been completely out of Derek's reach while he was driving or at any other time. It's just not, it just doesn't fit. It's not something that was in his control. The
okay,
car might have been in his control, but the baggie was not in his control. And as far as I know, he did not even know there was a baggie over there.
okay. And
Okay.
Mr. Lawrence, you just stated that you're not sure of what the officer did to the purse or when he unsnapped the purse. Um, I believe that if we were to call the officer as a witness in trial, we'll be able to answer that question, or that officer may be able to give us more insight as to what he did with the purse when he took it out of the vehicle.
It's on video. He's definitely turning the snap on that purse, closing it back. Now, what he took, whether he took something out of it, I have no way of knowing.
Okay, and that officer would be able to answer that question.
Okay. Now, Mr. Lawrence, are you finished with that motion?
Yes,
Okay.
that does it for that motion, Your Honor.
Okay, you'd like to present your argument on the second motion, which is motion to quash, and alternatively to set aside the information number 2? Or
Yes,
did you already, you want to proceed on that motion?
yeah, we can go ahead to
Okay,
do,
you may proceed.
sir?
You may proceed.
Yes, thank you. On motion to quash number 2, I go over much of the same scenario, but I point out this. After Officer Reeves had both parties handcuffed, and in a very rapid time, I believe he had the other officer, the younger or the newer officer, probably inside 2 minutes. I'm almost sure I'm very sure it's inside 2 minutes. He had him read both parties their Miranda rights at the same time, very rapidly. And then Derek, whenever he had done that, Derek did whisper protectively to Mistress Fields, "Don't say anything." That was his way of telling Mistress Fields, "Watch out." And then Officer Reeves then stated what I brought up in the first motion to quash. What I'm asking y'all is, whose synthetic marijuana is this? And if nobody claims it, I can charge you both with possession. And then he points at each of the parties and says, "Is it your marijuana or is it your marijuana?" And there were no answers by either party. And he says, "All right, that's the way we're going to do it. Right now, you're both under arrest for possession of marijuana." Then he told them to be seated in the squad car. So they're cuffed, they're both handcuffed, and they're both told to sit down in the squad car. That is effectively an arrest under Texas law. Now, and the Officer Garcia, who is with Officer Reeves, states in his supplemental report, after being Mirandized, neither Howard or Fields claimed possession of the substance or admitted knowledge of how it appeared in the vehicle. Being that neither claimed possession, both Howard and Fields were placed under arrest for possession of a controlled substance. And this wording, similar wording, not this wording, but similar wording, also appears in the probable cause affidavit. Now, the thing I hadn't emphasized in my first motion to quash that is key, this constitutes an unconstitutional arrest under Miranda versus Arizona, 384 U.S. 436, 1966, and the 5th, 6th, and 14th Amendments described therein. Also, you should be aware of it violates Rhode Island versus Ennis under the deliberate elicitation doctrine. The citation on Rhode Island versus Ennis is 466 U.S. 291, 1980. And the deliberate elicitation doctrine is discussed in Rhode Island versus Ennis and in the footnotes in that
Okay,
case.
now, before you proceed, did you just cite Rhode Island in the,
No, I didn't
This
cite it
motion?
there, but I have this, I have the
Oh, okay.
citation here. Rhode Island versus Ennis, 466 U.S. 291, 100 Supreme Court Reporter 1682,
1682?
1682, 64 Lawyers Edition 2nd, 297. And the deliberate elicitation doctrine is set out in the text, and it's also discussed in the footnotes in Rhode Island versus Ennis.
Okay, now you said 64 Lawyers Edition, what?
64 Lawyers Edition 2nd, 297.
Okay,
Good. And as I recall, there are other cases implicated that are about Miranda and the attempt to, well, basing an arrest almost entirely on the failure to give a forced confession. That's what this is all about. When I began to see is they had just been told they had the right to remain silent. And then immediately he says, was it your marijuana or was it your marijuana? And neither one of them says anything. He says, well, then you're both under arrest. He's just violated their Miranda rights and their right to remain silent, as well as their right to have an attorney present all over the place. And so for that reason, as well as the guilt by association, it's an invalid arrest. It's inherently, this is what I'm trying to get across. It's inherently an invalid arrest. And there was no other basis for arresting Derek. Now, the baggie of marijuana was very close to Jaylon, and it was either in her purse or right on top of it, or right under it. It was either in or beside her purse. That's obvious when you see how the officer doing the search recovers it. He's still looking, he's still in the same posture, he's still looking straight down where he just lifted up the purse, everything. It's obvious it was at the same location. And that was right beside the passenger door, because he had his arms reaching over and touching the passenger door, because that's as far as he could get his body in there. His head was sticking in the window, and that's as far as he could get his body in there. And I'm trying to remember, but I think the seat was still back. He just had his head stuck in there, and he had his arms like that, right next to the door. Derek Howard could not have had control over the marijuana in any way, it was inaccessible to him. And from what I understand, he didn't know it was there. And so this is like, and you've got to remember too, that she then, after she had sat in the squad car and as they were pulling them out of the squad car, she asked for her purse. And then she said the stuff was mine. And the officer asked her, this is in this part of the tape is in the motion to dismiss. I've quoted from that part of the tape in the motion to dismiss. She admitted that the stuff or the marijuana in the purse was hers. The officer directly asked her, are you saying the marijuana was yours? Yes. She said yes. And I've given the exact quote in the motion to dismiss. And it's on video. This is just, she showed up over where Derek was staying. Her car was not in good shape. And she had all her plans had fallen through. And so Derek tries to cheer her up and takes her out for a little ride around Beaumont there. And I don't believe she still lived in Beaumont, so that might have been part of it. I'm not sure. Is that correct? Yeah, she didn't still live in Beaumont. So that's it. That's it for the case. This is putting any kind of culpability on Derek is not only inappropriate, it's invalid under the law, including constitutional law, the 5th, 6th, 14th Amendments. It's and that would be the point, one of the points this case hangs on, is that there's no basis for his arrest.
Yeah, say something.
Okay, Ms. Musgrove?
Yes. So first, I'd like to state that Mr. Howard and Ms. Fields, they were not arrested for remaining silent. They were arrested for their possession of a controlled substance. Secondly, I'd like to state that the video does not show the location of the marijuana, so it's incorrect to say that it was in Ms. Fields' purse or near Ms. Fields' purse. We can't say that. Mr. Lawrence, throughout the video, or at the beginning of the video, when Mr. Howard and Ms. Fields were asked by the police who the marijuana belonged to, neither admitted that it belonged to them. And there is a portion of the video where Mr. Howard and Ms. Fields are in the back of the car. So there's parts of the discussion that we do not have that are inaudible, but Ms. Fields, I believe she begrudgingly gives a statement to the officer. At that point, the officer doesn't accept whatever statement that she made. But if we were to play the video for a jury, I believe that the video would show that Mr. Howard is attempting to coerce Ms. Fields into stating that the marijuana belonged to her.
Okay.
All right. I will go into that for the sake of this. First of all, the video plainly shows the officer does not shift his position after he pulls the purse out and puts it on the roof of the car. The camera angle does not change. The officer does not shift his position. he's still leaning, he's still got his whole arms being supported by the door, under both arms, and his head sticking in the back, behind the car seat, and reaching straight down where he got the purse. The marijuana came from exactly where the purse had been, behind her car seat and next to the outside door. There's no question about that, and that is on video. Anybody can see that for themselves. But I'm having trouble remembering the last point that she raised.
Ms. Musgrove, could you repeat yourself? You said he's having trouble remembering the last point that you raised.
So the point regarding Miss Fields' statement to the police after sitting in the back of the police car.
Oh, thank you. I remember now. I want to say this. Today, and you probably haven't seen it yet, Ms. Musgrove, but today I just filed a motion to suppress the discussions between defendant and Mrs. Fields in the back seat, because they didn't know they were being recorded, among other things. I did file a motion to suppress that today, but for the sake of the judge, I will go into what you just said. If you listen,
Okay.
as you said, some of it is inaudible, but
Right.
if you listen to it very, very carefully, and I went back and listened to it because you mentioned this to me, Mr. Howard, is very concerned at that point in time that if he gets any kind of adjudication from this, that his parole could be revoked. And he is on parole, something like a very lengthy, right now, he has 8 years left on his parole.
Right.
So he was trying to get her to admit that, and it was he was discussing it with her in a very low tone, but he was trying to, not knowing that he was being recorded, he was trying to get her to admit that the stuff was hers. But in fact, the stuff was hers. So he was just trying to protect himself in terms of his parole that he was on, so he wouldn't be revoked.
Okay.
There's no doubt, if you listen to the content of what he's saying, there's no question about that's what he's doing.
Okay.
But he is not trying to get her to make a statement that exonerates him, because he did not know that the marijuana was there when she got in the car. She had just come into his life again long after they had been together, some 5 or 6 years before. She had just come into his life again, and he was trying to cheer her up. That's what this is about. And she happened to have, she was going to go partying. Her partying plans fell through. That's probably why she had something in her purse. And it wasn't very much.
Okay.
If you recall that after it was weighed, this is before they've removed the seeds and stems and everything from the green leafy substance. After it was weighed at the lab, it was 0.75 ounce. And this was without removing all the other stuff that is in there that should have been removed. That's barely enough, from what I know about it anyway. That's barely enough to make one cigarette, one marijuana cigarette.
Okay. And I'm so sorry, Mr. Lawrence.
The whole idea of them that they were going out to smoke pot or something, that's way out there, because there's not that much there. And plus, from what I know about it, and this again goes back to what the owner of Sunrise told me one time about when they first began making marijuana smell like potpourri, women like the potpourri smell on their marijuana. And it also kills the smell of the marijuana somewhat. So the fact that it's been sprayed with potpourri to make it smell better before she put it in her purse or did whatever she did with it is very obviously, and the officer even said when he first was standing outside her window and it was only rolled halfway down, that he detected the faint odor of potpourri. It's very
Okay.
obviously her stuff. Men are not crazy about the smell of potpourri, but women like to have that smell on their marijuana. I'm just telling you what I learned after talking, particularly after talking to the owner of Sunrise a couple of decades ago, when they were selling,
Okay,
began to try to sell that kind of marijuana. And it didn't
so
last.
Mr. Lawrence, and just respectfully, synthetic marijuana, most of it does smell like potpourri. I've learned that at the Jefferson County Crime Lab, that's how officers most times make the distinction between synthetic marijuana and regular marijuana. And you mentioned the amount that was found, and I just want to state that the amount has nothing to do with ownership of the synthetic marijuana. Back to your point, you continue to state that the synthetic marijuana was inside of Ms. Fields' purse, and I'm going to continue to state that we cannot state that it was inside of Ms. Fields' purse, that it was found on the floorboard, not in her purse. That's, at this time, that's all I have to state.
Okay.
I would add one thing, and this is largely secondhand information, but when the owner of Sunrise, it was a shop on South 11th, when the owner of Sunrise explained to me that they could spray marijuana with potpourri to make it smell better for the brief period of time that they were selling it like that. He also said that there were 2 other sprays they could use, but potpourri did seem to be very popular. But it, again, I think women preferred potpourri to the men who didn't really care about whether it was sprayed and smelled good or not. But
Okay, and I'd like to state that,
I'm not trying to be argumentative.
okay, and I'm not either. Men and women both use synthetic marijuana. And as I stated, synthetic marijuana does oftentimes smell like potpourri.
All right.
Okay. Okay, that concludes the hearing on these 2 motions. The court is going to take these matters, these 2 motions under advisement. At this time, we're going to take a recess.